Mr Humphreys.
May it please your lordships, my lady, I appear for the appellant, my learned friend Ms Gray, and my learned friends Mr Dunlop and Mr Fletcher appear for the respondent. My lords, my lady, this appeal raises two issues which, as we say in our written case, explore some of the outer reaches of the doctrine of restraint of trade. And we have, of course, borrowed that phrase from the judgment of my Lord Wilson, given recently in this court in the Egon Zender and Tillman case. In that case, my Lord helpfully engaged in some historical analysis of the ancient origins of the doctrine and some of the key developments over the years in the common law. At one point, however, your lordships had to stop and say, well, there are outer reaches here, but they don't really apply because we're in a classic employer-employee situation. We don't need to explore some of the more difficult issues that are thrown up by cases like Esso Petroleum and Harper's Garage. However, it may be now that the time has come to explore those outer reaches, given that we're dealing today not with one of the paradigm cases of employer-employee or vendor-purchaser of a business, but rather with the vexed question of how, and indeed whether, the doctrine of restraint of trade applies to land agreements and restrictions placed on the use of land through the conveyancing process.
Can I just add an extra point, which is it's not a restraint on a trader, it's a restraint on a developer.
Yes.
As far as I'm aware, there's no case which includes that even in the outer reaches, but you'll no doubt come to it.
Indeed, Lord, and this is a key point that I'll try and make good early on in my submissions, the distinction between the position of Mr Shorthall as a property developer and the position of many of the litigants in previous case law whose actual trade was impacted by the restriction. Here specifically we are considering two issues. Firstly, does the restraint of trade doctrine apply to a restrictive covenant entered into by a lessor to the benefit of a lessee relating to the remainder of the lands, in this case adjoining lands? And secondly, does the doctrine extend to the purchaser of freehold land taking on the covenant as a successor in title? And there are perhaps, whilst there are two issues, we say there are three key arguments. The first of those arguments concerns whether, in fact, the restriction which Mr Shorthall accepted could properly be described as a restraint of trade at all. And of course, if your lordships and your lady determine that that's not a restraint of trade, then no further questions need to be asked about its reasonableness, nor indeed do we need to explore issues 2 and 3, or arguments 2 and 3 rather. Argument number 2 is an extension really of 1, and it concerns the relationship between adjoining landowners. It raises issues about enforceability of covenants, both in freehold and leasehold land, and in particular whether the restraint of trade doctrine can ever operate in that sphere. And the third argument concerns the successor in title, that even if the court were to determine that the doctrine had application between the original parties to this transaction, whether or not it extends to a successor in title in these circumstances. However, before I go to those arguments, I'd like to just look briefly at the factual context and just at some of the documents that were before the court at first instance and were considered by the Court of Appeal. In August of 1980, Mr Shorthall, the individual, was registered as the owner in fee simple of lands contained in the folio 25992 County Londonderry. Planning permission having been granted that same year for the development of Springtown Shopping Centre. It seems from the evidence that Mr. Shortall acquired title the year before, but wasn't registered until 1980. Then, by the lease dated the 2nd of February 1981, Mr. Shortall demised part of those lands to the appellant Dunn Stores, an area of about 1.05 acres for a term of 999 years. The lease itself can be found at page 1905, the electronic bundle numbering.
This Appendix Part 2, Mr.
Yes,
Humphreys?
indeed.
I've got Appendix Part 2 without the MS numbering. So could you give me a tab?
I will, of course. The appendix isn't tabbed. So, apologies, it's not tabbed, but on my version of Appendix 2,
give me another.
page 304.
I've got earlier numbering, which you may also have.
I hope, does your Appendix 2 begin then at 225?
It does.
Lord? Yes, very good, Lord. Then the lease is found at 304.
Thank you. Yes.
And we can see the terms of the indenture, the date of the 2nd of February 1981, the parties, and then the consideration was paid of £50,000. So Dunn Stores pay a premium of £50,000 and then agree to pay an annual rent of just £100 per year for the period of 999 years, subject to the covenants contained in the relevant schedules. The actual demise is at page 305 then, or 1906, of 1.05 acres. And the relevant covenants that we're considering are in the third schedule, page 308 or 1909 on the electronic numbering. And these are the covenants entered into by the lessor. And B is that any development on the lessor's lands comprised in the lessor folio and on his other lands adjoining the premises shall not contain a unit in size measuring 3,000 square feet or more for the purpose of trading in textiles, provisions or groceries in one or more units. So that, if you like, is the primary restrictive covenant accepted by Mr. Shortall at the time, not to cause any development either on the retained lands or the adjoining lands.
And does that apply solely to the land he owned at the time?
Yes, my lord.
Yes. So, I mean, if he acquired more land later, that wouldn't...
That's right.
caught by that.
Whether it was adjacent or proximate or land somewhere else entirely, that covenant wouldn't be engaged, my lord.
We don't have a map of that, do we? Or perhaps we do.
There is a not very helpful map in the papers. We do have a better map, my lords, my lady, if it would be helpful to hand it in. It's a land registry map that's much clearer than the old leasehold map that is in the papers, if that would be convenient.
You got the appropriate number of copies now?
Yes, we do.
Oh, good. Well done.
We should have included this in the papers, but it only really occurred to us late in the day that the map wasn't very clear. There are 2 pages to the map, but the second page isn't really relevant for purposes of understanding the demise, my lord and lady.
Okay.
So the shaded area is the area that's being leased, is that right?
No, in fact, the area being leased is outlined in green with a small letter C, my lord. So it's to the right of the map. The folio,
Right.
the folio is outlined in red, 25992, and then the area, the subject of the lease, is Little Green C.
And what's the shaded area meant to represent?
I think that's the car parking area, as I understand it, my lord.
Oh, okay.
You'll recall that there's an obligation to construct. In fact, there was car parking constructed by the appellant.
So the land which is subject to the restriction is the folio area, which is the red area, is that right?
Yes.
B, plus any other land he owned at the time. is
That's correct. The other adjoining land, the other freehold adjoining land.
We-
Yes, I wanted to ask about that too. Looking at B in the third schedule, any development on the lessor's lands comprised in the lessor's folio and on his other lands adjoining the premises. Now, can you distinguish for us folio land and other lands, please, Mr. Humphreys?
There are other lands in his ownership which are adjacent to this, but I can't on this map define that. If I can come back to that point, I'll ask my instructing solicitor to see if we
If you could,
bring
please.
some definition up, but there are other adjacent lands owned by...
Well,
Mr.
there
Short
were,
at that time.
presumably.
There were at that time.
Time, yeah.
There were at that time.
And so the folio, we can see the folio
Yes.
lands here, can we?
We can, outlined in red,
Outlined in red.
and that's about 5 acres, and then the area leased is 1.05 acres.
Okay, come back to that, Mr.
I
Humphreys,
will
please.
do. Thank you, Lord.
Thank you. Yes.
So as I say, the restrictive covenant at third schedule, small b, is the one in relation to the size of retail units for particular purposes. There's then at D, a positive covenant on the lessor to construct a minimum of 6 shop units suitable for retail trade to the reasonable satisfaction of the lessee in an enclosed mall. And one can see that that's the thinking behind this development, that one has an anchor tenant and a smaller mall of smaller shop units adjacent to the appellant's premises. The obligation then at G on the next page is in case the said shop units or other premises, lessor's adjoining lands or any part thereof shall be sold, conveyed, demised, licensed or otherwise disposed of by the lessor or become vested in any other person or persons whomsoever, the lessor will so deal with the said premises or part thereof only on condition that the purchaser or lessee or other person to whom any interest or licence respecting the said premises shall be disposed shall enter into a covenant for the benefit of the lessee that he or any person deriving title under him shall observe the covenants on the part of the lessor and conditions herein contained, and the lessor further covenants that he will at the request of the lessee join the plaintiff in any action by the lessee to enforce these covenants and the conditions. So, my lords and lady, in fact, if called upon under the terms of this lease, Mr. Shorthall would be obliged to join in with the enforcement of a covenant against Peninsula Securities. Now, that's obviously not where we are, and there hasn't been any steps in that regard, but it illustrates the intent of the parties at the time they entered into the covenant that similar covenants would be imposed on any successor in title. So those are the relevant obligations. And of course, there are parallel obligations on the lessee in the preceding second schedule, as one often sees in this type of transaction. There are some factual issues in the background that are not in dispute. After the lease was executed, the £50,000 premium was paid, and the appellant constructed the shopping centre and the car parking spaces in accordance with the development concept. And indeed, we know from the evidence of Mr. Shorthall that he was successful, I think, in letting 14 other retail units on the premises in the initial period after the anchor tenant took up occupation and the shopping centre opened for business in the latter part of 1982. Mr. Shorthall, as an individual, clearly derived benefits from this arrangement. In the first instance, he received a capital payment of £50,000, but perhaps moreover, from his perspective, he acquired a significant player in the Irish retail market into this part of the island at a time when, in his own colourful evidence, this part of Londonderry was something of an economic wasteland.
Duns has a big reputation, does it?
Yes, Duns would be, both north and south, would be a significant figure in the area, both of groceries and of clothing and other provisions.
Where exactly in Londonderry is it?
So this is in the Springvale area, although it's called Springtown Shopping Centre, the surrounding area is called Springvale. Your Lordship may have some memories of the city from years gone by, as I understand it. And I'm not sure I could navigate quite to it, but it's in an area of the city that, on Mr. Shorthall's evidence, was run down, was having difficulty in successfully developing. There were obviously issues with the Troubles and with poverty in that part of the city.
Is it in the northwest?
Yes, it is.
Yes.
So having secured both his capital money and his anchor tenant, Mr. Shorthall was also able to secure some infrastructure by way of the car parking and the natural draw of an anchor tenant for the benefit of the smaller stores and for the community in general. So this is not a situation where one looks at the bargain struck by these parties and thinks of the doctrine of restraint of trade. It doesn't immediately occur to one that, for instance, there's been any inequality of bargaining power or that there's been any abuse of power by one of the parties.
But presumably it was important to Duns that they shouldn't have next door and competing with them an equivalently sized store.
Indeed. And that's reflected in the nature of the covenant itself, that it's not an utter prohibition on the selling of goods which may compete with Duns stores, but it's the selling of those particular goods in a retail unit of a given size. So there was no objection to having a small clothing retailer or grocery store, but it's the comparable size of competitor that Duns stores sought to exclude. And one sees this on a reasonably regular basis in the way shopping centres are structured, that there is a key anchor tenant followed by some smaller retail units in this kind of arrangement. And significantly, on that subject of trade, there's no doubt Duns stores carried out the business of trade in groceries and textiles throughout Ireland, but that's not what Mr. Shorthall did. Mr. Shorthall, on his own evidence, was a property developer. He was interested in developing a shopping centre. He wasn't interested in selling any of his own goods or providing his own services. And we say that that's a significant feature of the case, and I'll come back to its impact on the doctrine in due course. We also know that in April of 1983, Mr. Shorthall transferred his freehold interest in the lands to a company controlled by him, the respondent in this case, Peninsula Securities Ltd. And the land certificate can be seen at electronic numbering 1946 of the same file, Appendix 2.
If you say we need to go there, then we will. But
No,
do we?
No, just for your
Okay.
notes. And that transfer effected also an assignment of the rights under the lease. 1983, and then 17 years later, the respondent company commenced proceedings in the Lands Tribunal in Northern Ireland to have this covenant, these covenants modified or extinguished under the provisions of the Property Northern Ireland Order 1978. Now,
Will you be telling us a bit about that order?
I will do.
We want to understand its origin, the thinking behind it, why, if it be the case, England and Wales has nothing comparable, etc.
There is an interesting history there in that Northern Ireland never had the Birkenhead reforms, the Law of Property Act and other legislation associated with that in the 1920s, partly as a result of the partition of the island and the devolution of administration to the north of Ireland, but also partly an historical division between the property laws in these islands. And never having had the Birkenhead reforms, it didn't have the provision in the Law of Property Act 1925, which permits modification of covenants. And so it wasn't until, I think, 1970 that reform was recommended in Northern Ireland, things taking, as they do, rather longer sometimes on that side of the Irish Sea. And ultimately, the 1978 order was enacted. We'll go to its provisions in due course, but it's obviously it was known significantly to the parties entering into this lease in
It
1981.
might just be interesting for us to look at the 1925 provision,
Yes.
which Northern Ireland doesn't have. If Miss Gray had time today to locate it, that would be great.
Yes, we'll do that. I think it might be section 84.
Thank you.
But it was certainly known to the parties when they entered into this lease in 1981 that there was a new, very new provision in Northern Irish law which potentially allowed for restrictive covenants to be modified or indeed extinguished. Now, the legislation itself suggests a period of 21 years needs to elapse before such action can be taken, but that is subject to a discretionary reduction in time on the part of the tribunal. But that's a part of the context of the drafting of the lease that I will return to. The Lands Tribunal proceedings then morphed into High Court proceedings because of this issue of restraint of trade. The Lands Tribunal not having any jurisdiction to address that, litigation then ensued, which involved not only allegation of breach of the doctrine of restraint of trade, but also a claim under Section 2 of the Competition Act 1998.
Reading it through yesterday, I did want to be absolutely clear that the Lands Tribunal litigation is totally at an end, and equally, if it be the case, that the agreement to arbitrate is totally at an end, and that everything is now in court.
Yes, I believe,
is that right?
I believe we're agreed that that is the case, my
Very
lord.
well.
That there will be one single determination of all the outstanding issues, whatever the outcome of this particular appeal. As the court will be aware, Madam Justice McBride dealt with this discrete issue of the applicability of the doctrine as a preliminary question and determined that the doctrine did not apply. Then the Court of Appeal allowed the respondent's appeal and remitted all the issues back to the High Court for determination. And here we are on foot of the court's permission to appeal that decision. So on the first question, this is, does the doctrine apply at all to this situation? We respectfully say it cannot. And before I look at some of the authorities in an effort to make that submission good, it's useful to go back to some just first principles. The restraint of trade doctrine itself is concerned with circumstances in which the law will intervene to render the party's bargain unenforceable, even where there's no vitiating factor that can be identified. It's an unusual doctrine in the common law, in that it's a clear interference with freedom of contract that can be invoked even where there's been no wrongdoing, whether innocent or otherwise, on part of one of the parties. So we say from that first principle should be derived the point that the circumstances in which the doctrine applies need to be carefully delimited. There are some statements in the authority, some dicta, which seem to offer a very wide view of its applicability, and we say respectfully those cannot operate in practice. And the language itself of the phrase restraint of trade is of significance. The use of the word restraint, we say respectfully, is indicative of an enforced deprivation or diminution of liberty. The use of the word trade, we say, must mean the buying and selling of goods and services. That's what lay people, and indeed lawyers, understand trade to mean. Therefore, on that basis, the doctrine should be concerned with, and is concerned with, the extent to which the courts will police contractual arrangements freely entered into, but which cause some deprivation in the ability to buy and sell goods and services. And we think of the case, for instance, of Schroeder and Macaulay, the young musician who enters into an agreement with a large publishing company, the terms of which are particularly unhelpful and onerous to him, where he's left in a situation he may not earn any money at all, and there's really no obligation on the company with whom he's in contract to promote or sell his work. And the court intervened there, and one can see why, because there's a young, talented individual whose ability to carry out his trade and profession has been restricted by a contract in circumstances where there's clear inequality of bargaining power and an ability to use that inequality to restrict the basis upon which the company would have to work.
Would you like to give us a reference to that authority?
I will, of course, my lord. It's to be found at it's in volume 3, tab 40.
Thank you.
The electronic numbering is MS 882.
Very well.
Now, one contrasts that type of case to the instant one. Here, Mr. Shorthall entered into a covenant to ensure that his land, adjoining that leased to Dunn Stores, would not have any units of over 3,000 feet retailing groceries, textiles and provisions. Otherwise, he was entirely free to do with that land as he pleased, subject obviously to planning constraints. And notably, he personally did not give up any relevant pre-existing trading, since he never engaged, or at least there's certainly no evidence that he ever engaged, in the retail of groceries, provisions, or textiles at all. We say then, as a matter of principle, the doctrine should apply to land transactions, land agreements, only rarely, and only where the covenant in question impacts on a pre-existing trade enjoyed by one of the parties.
Mr. Dunlop is going to submit that you are misquoting the Esso case there, and that we're not, if we're talking about giving up pre-existing things, it's not pre-existing trading, it's pre-existing freedom, is what he's going to say.
Well, we say the jurisprudence properly analysed is all concerned with trade and not with the development of land. The Petrofina case has a useful statement from Lord Denning that can be found at MS 387, which is volume 2 of the authorities. It starts at MS 363, tab 19.
Yes.
And as the court will be aware, it's one of the many solus agreement cases that troubled the courts in the 1960s and 70s. But I don't need to go to the facts of it. I just want to go to the particular statement of law by Lord Denning at page 387, where at just 5 lines down from the top of the page, the sentence begins, "No doubt in our law." He says, "No doubt in our law of land, a covenant can be placed on a piece of land so as to prevent any trade being carried on there or any particular kind of trade."
Beg your pardon, I'm not with you. Which passage are you looking at?
Sorry, it's MS 387.
Yes,
It's 5 lines from the top of the page, beginning "No doubt."
I've got it. Thank you very much. I'm sorry.
My Lord. So, "No doubt in our law of land, a covenant can be placed on a piece of land so as to prevent any trade being carried on there or any particular kind of trade. To such a case, the doctrine of restraint of trade has no application. But when we come to covenants which restrict a tradesman in the way he may carry on his trade on his own land, then we get into the realm of contract. And the doctrine of restraint of trade does apply, and there are many cases of this kind. He goes on to cite a number, including the dairy farm case, McAllister. So that
I
distinction...
think I'm being very slow, but I don't immediately understand the factual distinction which is being posited there. What is it, Mr. Humphreys?
That the restriction on land is different from a restriction on trade. And so in the simple case of a solus agreement, where a petrol station retailer enters into a bargain with an oil company where he will sell exclusively their fuel, that restricts a tradesman in the exercise of his trade, his ability to buy and sell goods freely. However, land transactions are different. And in the classic case, which the doctrine does not apply to, if the oil company own the petrol station and a retailer comes along and takes a lease of it, and as part of those arrangements, there's a solus covenant in the lease, then he can't complain subsequently about that provision. It's a covenant attaching to the land that has the effect of restricting his trade, but is fundamentally different from the retailer who already enjoyed those privileges of buying and selling at liberty on his property, who then enters into an agreement. And I think that's the distinction.
Sure, it's a more fundamental distinction than that. Or Denning is saying that there's nothing to stop a piece of land being restricted as such. The thing that brings it within the doctrine is that a particular trader is occupying that land, and so the restriction on the land prevents him carrying on his trade. And all these cases are examples of that. But what it's not saying, I mean, a developer who decides that he wants to restrict a piece of his land to certain uses is not in the doctrine at all.
Yes, well, that's hopefully the direction of travel I'm trying to get to. The distinction between trade and property is an important one to bear in mind, because it does run through the cases. There is every case in which...
I mean, you say it runs through the cases. In that statement by Lord Denning there about the position of a restriction on a piece of land, I mean, he says it as though it's perfectly obvious. Has it ever been doubted as a proposition? I mean, are there any other cases which consider the position of a lessor developer putting a restriction on the land?
No, there are not.
All these cases, I understand, are cases of trader occupiers.
Exactly.
Who are accepting a restriction on their ability under a particular lease to trade.
Yes, and we see the the distinctions drawn between those traders and when they can invoke the doctrine, when they can't. But indeed, your lordship's quite right to say these are different conceptually from the lessor who himself adopts or accepts a restriction on.
But if the lessor was a trader, then there might be something in the point. But if he's simply a developer who's concerned simply with what happens to his land and how he can use it, that's a different thing.
Indeed, and the developer will want to create a parcel of rights and obligations between him and the retailers who may use his land in the future. But that's an entirely separate concept from the retailer who finds himself in the difficulties that the petrol station owners did in the Solus agreement cases.
Sorry, is the Master of the Rolls there looking at the present kind of case at all? Has he got that in his mind, or is he simply considering, as my lord says, in that first part of the passage, the position of a trader who takes a lease or acquires land which is subject to a covenant? Previously, he had no right to do anything on that land because he had no right in the land at all.
That's right.
That's a very different case from the case where a property developer has a good deal of land in his ownership and enters into a covenant in respect of the land which he previously could enjoy as he wished.
Indeed. And that's quite correct.
And is Lord Denning considering that latter case at all?
He's not. And what we're trying to do is look at the analogy with the lessee and see how that impacts on the position with the lessor. And again, the distinction is not just between lessor and lessee, but between trader and developer. And I think the recognition on both sides is that there is no authority that bears directly on the position we have in the instant case.
Do the other judges say anything about that? And you have Harman and Diplock, so it's quite a strong court.
Both Lord Justice Diplock, as he then was, and the Master of the Rolls make very wide propositions about contracts and restraint of trade. Both of those are doubted subsequently in ESSO as representing a true statement of the law, because they both suggest really that anything that restrains trade is potentially unenforceable unless reasonable, which subsequent authorities thought that can't be right, given that the very many commercial contracts and contracts of engagement of services necessarily involve a restraint on one's ability to trade goods and services elsewhere. But apart from that, there's little in Petrofina that is helpful on this, and it's not overruled in ESSO, but it's distinguished and not relied upon in terms, but certainly by Lord Reid. It might be useful just to turn to some of the passages in ESSO and Harper's Garage, and this will impact upon both the question at hand, but also on the bigger picture that your lordships and your ladyship will have to consider, whether this court is going to consider a new test or an alternative test for the applicability of the doctrine of restraint of trade. Of course, the court may determine the matter narrowly and simply say that the doctrine does or does not apply in these particular circumstances. But certainly the invitation is there in the respondent submissions to look at an alternative test, and it's also there through some of the jurisprudence of the Commonwealth states, particularly in Australia, where there has been a move towards a different test from the one that was propounded by the majority in ESSO.
Has any judge ever accepted an invitation to try and define the boundaries of the doctrine?
I don't think they have, and I think perhaps wisely. It's also quite instructive even to look at the academic papers written on the subject, many of whom are quite critical of some of the appellate level attempts to create a test or bring some definition to the boundaries of the doctrine. But the academics themselves, notably, don't really succeed in defining the boundaries themselves. So quite easy to be critical and perhaps more difficult to be creative in this field. So there's little in the way of settled agreement about what the test might be, even if there is some agreement about what it definitely does and does not apply to. The SO case is found in the MS 105, which is in the first bundle of authorities at tab 10. And again, the facts of the case are well known. The two separate solus agreements, one of which was part of a mortgage arrangement, and were in both cases were found to be subject to the doctrine, albeit with differing outcomes in terms of reasonableness. The arguments of counsel for the appellants, Robert McGarry, Queen's Counsel as he then was, begin at page MS 111. And the primary submission was an attractive dichotomy that the appellants sought to bring between contracts in restraint of trade, and secondly, between restrictive covenants affecting land. And so in the primary submission of the appellant, only the former could ever be subject to the doctrine. Counsel submitting that covenants contained in leases, conveyances and mortgages have never been subject to the doctrine and the test of reasonableness. And in fact, you can see in about halfway or two-thirds of the way down the page reference to Section 84 of the Law of Property Act. That's the provision permitting modification of covenants in England and Wales.
Thank you.
We've picked that up, and we will get a copy of that for you over the luncheon interval, perhaps. The case being made by the appellants had the benefit of a simplicity, but it didn't ultimately find favour with the court, and one has to look at some of the problems that Mr. McGarry, Queen's Counsel, identified with not following his dichotomy at page 125. This was in reply to the Respondent submissions, and at the bottom section of MS 125 he says, a further demonstration of the unsoundness of the Respondent's test is provided by applying it to a parade of newly built shops owned by X. If X keeps number 1 and sells number 2 to A with mutual restrictions against a wide variety of trades, A's covenants will be within the exemption, but X's will not. So immediately one thinks that the pre-existing freedom test, which ultimately prevails with the majority, gives rise to this anomaly, in that if Mr. X has his pre-existing freedom to trade from the premises, but gives it up, and Mr. A has no pre-existing freedom but moves into the shop with that particular restriction, he'll not come within the doctrine. And one asks oneself, how could that logically work? Because if, as most of the authorities say, the doctrine is all about public policy, then why would the public policy be different for these two adjacent shops if one of them potentially can trade as he pleases despite a restriction and the other cannot? And then he further goes on to say, and if X leases number 3 to B, with similar mutual covenants, B's covenants will be within the exemption, but X's will not. And then if B seeks a license from X to sublet number 3 to S with a variation of the restrictions, and X grants the license subject to S covenanting with X, as well as with B. S covenants will be within the exemption code B, but not, it seems, code X, and so on. That all comes from the same basic principle that the owner of the property who enters into the restriction would be subject to the doctrine, whilst a lessee of neighbouring premises would not. And it's not something that the lordships really grapple with in the speeches, how this anomaly that was identified by counsel for the appellant would work in practice.
So when Mr. McGarry is talking about within the exemption, he's talking about within the exemption from the application of the doctrine.
Exactly.
Is that right?
Exactly.
Very well.
The doctrine does not apply.
Yeah, quite. Thank you.
Even though the restrictions would be presumably identical. So in the speech of Lord Reid then, picking up at MS 131, he says at paragraph F, it's much too late now to say that this rather anomalous doctrine of restraint of trade can be confined to the two classes of case to which it was originally applied.
Two original clauses being?
That's the master-servant, employee-employee relationship, and the vendor-purchaser of businesses. So one can sense a tone of regret that it couldn't be so confined. But as the learned Lord goes on to say, but the cases outside these two classes afford little guidance as to the circumstances in which it should be applied. In some, it's been assumed the doctrine applies, and the controversy has been whether the restraint was reasonable. And in others, where one might have expected the point to be taken, it was not taken. So he lays up the general proposition that nobody could deny that the boundaries of the doctrine have proved difficult to define at any level. At 133D, that's the MS 133, I just want to pick up this point because I'll be, towards the end of my submissions, talking a little bit about whether covenants and restraint of trade are void or unenforceable and whether that matters. And just to pick up the point that the view, I think unanimous view of their lordships in Esso Petroleum, as illustrated at letter E, is that it's only unenforceable. So that seems to be the theme of that particular judgment, although it's accepted that in other cases the word void is used. But I just want, for your lordship's note, rather than having to go back to the case subsequently in my submissions. He then picks up that the main argument submitted for the appellant in this matter was that a restraint of trade means a personal restraint and does not apply to a restraint on the use of a particular piece of land. Otherwise, it was said every covenant running with the land which prevents its use for all or for some trading purposes would be a covenant or restraint of trade, and therefore unenforceable unless it could be shown to be reasonable and for the protection of some legitimate interest. And that's the conflict between the respective submissions. Over the page at the top of 134, his lordship says, as the whole doctrine of restraint of trade is based on public policy, its application ought to depend less on legal niceties or theoretical possibilities than on the practical effect of a restraint in hampering that freedom which is the policy of the law to protect. So it seems, in a sense, he's accepting the anomaly identified by Mr. McGarry, that it shouldn't be about the mechanism by which the restriction is created. It should be about what the public policy might actually be in either promoting or preventing that particular restriction. It's true that it would be an innovation to hold that ordinary negative covenants preventing the use of a particular site for trading of all kinds or of a particular kind within the scope of the doctrine of restraint of trade. I do not think they are. Restraint of trade appears to me to imply that a man contracts to give up some freedom which otherwise he would have had. A person buying or leasing land had no previous right to be there at all, let alone to trade there. And when he takes possession of that land subject to a negative restrictive covenant, he gives up no right or freedom which he previously had. And that's the essence of the pre-existing freedom test that the majority of their lordships adopted. At letter E, on the same page, he says, in the present case, the respondents, before they made this agreement, were entitled to use this land in any lawful way they chose. By making this agreement, they agreed to restrict their right by giving up their right to sell their petrol not supplied by the appellants. And therefore, he determined that it was within the doctrine of restraint of trade.
And as I understand it, what you say is, in this case, the person who would be giving up, there'd be no one giving up a freedom, because the trader we're talking about is a potential lessee of this land.
Yes.
It's not the developer himself, it's a potential lessee. And if he were to choose to come onto this land, subject to the restriction, he wouldn't be giving up a freedom that he previously had.
Indeed.
So that's the way you apply it, I think.
That's exactly the point.
Mr. Dunlop is going to say, well, it may be that Mr. Shortall, it wasn't giving up a freedom to trade. That's not realistic. He was giving up a freedom to cause or permit others to trade. Mr. Dunlop is going to say, what's the difference?
The difference is that how owners of neighbouring property choose to define their rights and obligations simply doesn't enter into this realm at all. If neighbouring property owners enter into mutual covenants, whether by sale of parts of land or by leasehold agreements, that, we respectfully say, simply is without this doctrine completely. Not just because of a pre-existing freedom test, but also because of the trading society test, which Lord Wilberforce propounded, in that a trading society wouldn't regard arrangements between neighbouring property owners as ever deserving of the invocation of this doctrine, and never has done, tellingly.
But this is rather different, isn't it? Because we have here duns who are traders in these goods, and they want protection against a competing trader with an equivalently sized outlet. Mr. Shortall owns this land, and I think you would accept that the doctrine would apply, the doctrine of restraint of trade would apply, in respect of a covenant by him not himself to open an equivalent store. Correct?
Yes, that's potentially right, yes.
But he's suddenly out with the scope of the doctrine if he licenses somebody else to do it.
Because the doctrine is all about personal trade and not about property.
I see, thank you.
That really is, we go back again to that fundamental distinction and why it is called restraint of trade, because that's the essence of the test.
Yeah,
What worries me about the pre-existing freedom test, as here articulated between B and D by Lord Reed, is, first sentence, restraint of trade appears to me to imply a man contracts to give up some freedom which otherwise, I emphasize that word, otherwise he would have had. Then he continues, a person buying land has no previous right to be there at all. When he takes possession of that land subject to a negative covenant, he gives up no right or freedom which he previously had. So he shifts from otherwise to previously. And when a man comes in, having had no previous freedom, but nevertheless comes in and says, yes, I will actually agree not to do X, Y, and Z, he's giving up a freedom that he would otherwise have had, but he's not giving up a freedom that he previously had. And so I have, very preliminarily, got concerns about this whole pre-existing freedom test, Mr. Humphreys.
No, I can see that, my lord. To make sense of it, it has to be previously, because otherwise engages any possible range of deals you could strike with a particular retailer or supplier, or indeed someone who was going to license you or lease you land. Otherwise, too broad a concept there. It has to be limited to previously enjoyed, I think, to make any sense of this notion of pre-existing freedom.
But what's the logic behind it?
The logic behind it seems to be simply that their lordships weren't content with the neat dichotomy advocated for by Mr. McGarry. They believed that it had to have some role in the property sphere, but wanted it limited as possible. They recognised that it didn't apply because it had never applied to lessees coming on to property for the first time, or indeed purchasers of freeholds who willingly entered into restrictions whilst purchasing a property. And so faced with that difficulty and the residual cases that they were concerned about, which were flagged up by these onerous soulless agreements, the way through that was found to be to identify that a pre-existing freedom had been given up. It certainly wasn't following a line of authority or principle, it seemed, but was fixing a problem that the common law had identified.
They don't, I mean, do they deal with the anomalies pointed to by Mr. McGarry, which you've highlighted?
Regrettably, no. Yeah. And that's a criticism levelled at their lordships by Dyson Hayden in his article in the LQR, that they failed to do this, and he flagged this up as a real continuing problem, as well as other issues that he had with the various speeches. But that one, he said, was left undealt with and represented a real issue because, as we see at the top of the page, it's all about public policy. So how could the policy be different for Mr. X than it is for Mr. A if our interest is in preserving the freedom to trade, or indeed in having a supply of goods and services to the public generally?
May I ask, so that I'm clear in my own mind, are you inviting us to depart from Lord Reid's analysis, which, as I understand you accept, was the analysis of the majority?
Our position is this, that on an application of Lord Reid's tests, our appeal should succeed in any event, because Mr. Shorthall, as a lessor, didn't give up any relevant pre-existing freedom, and that's a relevant pre-existing freedom to trade. If, however, the court is not content with the state of the law, that can see that there are anomalies created by this test that need to be further examined, we advocate for the trading society test, which I'm about to come to in the speech of Lord Wilberforce. And it's based on a flexible idea of sort of protean development of economic and social policy that will change with time, that will allow society to recognise that certain interventions with parties' freedom to contract are justified. One would have thought in a limited sphere, but nonetheless are justified, whereas society recognises that other restrictions are beneficial for development, beneficial for control of the use of land, or control of supply chains, or control of the way in which business is conducted in commercial terms. And that recognising those, society should simply say restraint of trade doesn't have a part to play in those at all. They're not subject to the second question of reasonableness. And we say that if that test is applied, equally, our appeal should succeed, because for the reasons both in the case law that exists and the case law that doesn't exist, it's quite apparent that a lessor in this situation has never successfully invoked the doctrine. And so applying the principle of the trading society test to this situation should mean that it's inapplicable unless some very strong reason could be shown for why that position should alter.
Now, let's proceed with Esso.
Yes. The next speech of Lord Morris, I can pick up at MS 145. At the top of the page, paragraph B, he says there's a considerable difference between the covenants in the present case and the covenants of the kind which might be entered into by a purchaser of a lessee. If one who seeks to take a lease of land knows that the only lease which is available to him is a lease with a restriction, then he must either take what is offered on the appropriate financial terms, or he must seek a lease elsewhere. No feature of public policy requires that if he freely contracted, he should be excused from honouring his contract. And that's an important statement of what public policy might mean in this context. Very often we're all guilty of using the phrase public policy without really trying to drill into what it means in a given situation. And there it is to say the lease was on offer, it contained a restriction. No doubt there were good and bad things about the offer on the table, but once you enter into it, public policy shouldn't turn around and excuse you from entering into that. And we say that there are strong echoes of that in this situation, albeit factually different, where a lessor freely enters into an arrangement which is mutually beneficial, where one's acquiring an anchor tenant with the retail draw and the money, as against having to accept restriction on the development of other lands which one owns adjacent to the lands leased, then there's no feature of public policy that suggests any basis for a lessor escaping the obligations that he has freely entered into. And again, just about 3 lines down, picking up at the sentence, his freedom to pursue his trade or earn his living is not impaired merely because there is some land belonging to someone else upon which he cannot enter for the purposes of his trade or business. In such a situation, that is, of voluntarily taking a lease of land with a restrictive covenant, it would not seem sensible to regard the doctrine of restraint of trade as having application. So in terms, Lord Morris is adopting the pre-existing freedom test, but he is expressly connecting it to public policy. We say that the application of that test does not benefit Mr. Shortall or indeed his successor in title. Mr. Shortall could have leased, if one looks at the anomalous situation, Mr. Shortall could have entered into leases with all the shops in the mall, the small 14 shops, and could have imposed a restrictive covenant on each of those not to sell particular products or indeed to be of a particular size. If he had done so, without regard to the situation with Dunnes Stores, on this analysis, those covenants would never have been subject to the restraint of trade doctrine. So any tenant who came in subject to whatever restrictive covenant Mr. Shortall sought to impose upon them couldn't have complained subsequently on the basis of the pre-existing freedom test. In the situation we're dealing with, the lessor covenant, Mr. Shortall is quite at liberty to do anything he wishes with his land, save for what actually amounts to quite a modest restriction in terms of size and particular goods. It's relevant, of course, it goes to the question of reasonableness, but it's also illustrative of whether any public policy point might come into play. Is one thing, as one of the other speeches in the case of Lord Pearce says about sterilising land. Is this sterilising land? Or respectfully, it's not, because all it can be seen to be doing is placing certain modest restrictions on its use. But I accept your Lordship's point that that would certainly be an issue to determine on the second question.
On your submission, if the covenant imposed on Mr. Shortall was completely unreasonable, would still be out with the doctrine.
That's right. And that would be no matter that it was 999 years, that itself wouldn't inure to the benefit of an argument that the doctrine applies. If it's out with the doctrine, that's the end of the inquiry.
Except it might be modified under the
Exactly.
statute.
And that's where these alternative arguments come in, that the law has now recognised that if there is a mischief, there's an alternative, or perhaps two alternative approaches to it. It would be open to a lessor or a lessee, or indeed a third party, to complain that some arrangement was in breach of the Competition Act, or indeed open to the lessor or lessee or their subsequent successors in title to seek the modification under the property order. So it's not that someone in a situation is left without remedy. It's just that they don't have the ability to invoke the doctrine of restraint of trade. And
It's of course, I mean, this case in 1966 was before the 1969 amendments to the Law of Property Act, Section 84. So I don't think it would have occurred to anyone at this stage that there might have been it could have been modified under this statute.
yes,
I mean, we'll no doubt come to the question of whether it could have been modified under the 1969 Act amendments. But it doesn't seem to be an issue at all.
No, it doesn't seem
There might
to
be an
be.
alternative statutory route.
no, I think that's absolutely right, my Lord.
Lord Conworth obviously knows quite a lot about the 69 amendments. I'm afraid I know nothing. So would you be able, at some stage, to educate the rest of us about it?
We'll do our very best, my Lord.
Thank you.
The speech of Lord Wilberforce, then, which engages this alternative test of the trading society, begins at MS 166. And at the bottom of the page, he begins, the first main issue is whether these agreements are to be regarded as agreements in restraint of trade, so as to be exposed to the test of reasonableness stated in the Nordenfeld case.
Now, I mean, you obviously want to get a move on,
I
but
do.
we have skipped Lord Hodgson and Lord Pearce. For my part, I would quite like to know how many of their lordships signed up to the pre-existing freedom test. It's certainly clear that Lord Reid, Lord Morris and Lord Hodgson did.
Yes.
I saw some reference in the papers to possibly Lord Pearce had too,
I think
but
that,
I wasn't clear about that.
I think that's possibly right in terms of Lord Pearce, because if one looks at MS 161, paragraph C, the one beginning, it seems clear. It seems clear that covenants restraining the use of land imposed as a condition of any sale or lease to the covenantor or his successors should not be unenforceable. It would be intolerable if, when a man chooses of his own free will to buy or take a tenancy of land which is made subject to a tie, doing so in terms more favourable to himself owing to the existence of the tie, he can then repudiate the tie while retaining the benefit. And then at F, he says, it may be, however, that when a man fetters with a restraint land which he already owns or occupies, the fetter comes within the scrutiny of the court.
I see. So that's quite circumspect.
Yes. So it's a limited recognition, I think, of the pre-existing freedom
Thank
test.
you, Mr. Humphreys.
The passage at F may be significant, may it not? Because no doubt that is a passage which your opponents will rely upon.
Yes, I think they may do, but it's not the view of the majority in this case. Lord Wilberforce then at MS 167 gives something of the history of...
You say it's not the view of the majority. I thought it was the view of the majority.
Well, I think the wider point that where a man fetters with restraint land which he already owns or occupies could be argued to engage a lessor who already owned or occupied, who fettered his own land. It obviously, if it's...
I see.
If that's the point to be made against me, we would say, well, if it is to be read into that comment, it's certainly obiter, and it certainly wasn't argued from the point of view of the lessor-lessee adjoining land relationship that pertains in the instant case.
Right, Lord Wilberforce.
Lord Wilberforce,
Bottom of 166.
bottom of 166 says, well, the first thing you do is say, well, are they regarded as agreements of restraint of trade? So you need to go to the second question of reasonableness. He gives some of the history through Nordenfeld and Petrus. And at D, just picking up 167, often in reported cases we find that instead of segregating two questions, one, whether the contract is in restraint of trade, and two, whether it's reasonable, the courts have fused the two by asking whether the contract is in undue restraint of trade or by a compound finding. So important, he notes, to do the questions in order. He says at 168E, about halfway through the paragraph, there will always be certain general categories of contracts as to which it can be said with some degree of certainty that the doctrine does or does not apply to them, identifying the same problem that Lord Reid did. And then at G, he says, how then can such contracts be identified? He goes on to deal with some of the historical cases, but 170F, he talks about leases. He says the working of the same principle can be seen even earlier in relation to covenants restricting trade and leases generally. In the normal exploitation of property, covenants are entered into by lessee or lessor not to trade at all or not to carry on particular trades. In 1614, Rogers and Parry, the issue whether a covenant and lease for 21 years not to exercise a particular trade was in restraint of trade was still susceptible of debate, but Chief Justice Coke and the judges of the King's Bench upheld its validity. By 1689, this seems to have become accepted doctrine, and it's noteworthy that the covenants there referred to are lessor or lessee. Chief Justice Holt was able to say it is usual to restrain a lessee from such trade in a house let, giving as the reason, for I can choose whether I will let the house or not. The same has come to be true of dispositions of the freehold. For over 100 years, it's been part of the normal technique of conveyancing to impose and accept covenants restricting the use of land, including the use for trades or for trade generally, whether of that conveyed or of that retained. A modern example of this is Newton Abbott and Williamson. One may express the exemption of these transactions from the doctrine of restraint of trade in terms of saying that they merely take land out of commerce and do not fetter the liberty to trade of individuals. But I think one can only truly explain them by saying that they've become part of the accepted machinery of a type of transaction which is generally found acceptable and necessary, so that instead of being regarded as restrictive, they're accepted as part of the structure of a trading society. And that sentence is probably the essence of the trading society test.
Mr. Humphreys, thank you for pointing out that at 170F, Lord Wilberforce talks about covenants by lessee or lessor.
Yes.
What are the cases on lessor's covenants?
Well, indeed, one might ask, where are they?
Where are they?
They're not to be found.
They're not to be found.
But he does give one at E on the following page.
Hind and grey.
The lessor's covenant is trading hind and grey.
Oh, yes.
Which we don't have in the
1840.
We have that?
We don't have it in the authorities.
We don't.
I did dig it out, and it perhaps would be worth having a look at it.
Yes, we shall indeed.
I mean, I
Thank
think
you
it's
for that.
rather
Lord.
And Aberdeen varieties,
Yep,
perhaps.
we shall have a look at those.
Would your solicitors be able, over the short adjournment, to get copies of those, or is that too much of an ask,
No,
Mr. Humphreys?
we'll certainly try.
Would you like us to do it?
No, I'm sure we can. I think we'll be able to.
Right, we want
assist.
5 copies of Hind and 5 copies of Aberdeen
My Lord,
at 2 o'clock, please.
indeed.
Test at 335 letter C, Lord Wilberforce's test.
Yes.
It's very much a retrospective test, isn't it?
It is.
And how would it adapt to meet new situations?
Well, one could see some of the academic criticism of it is that it will take time before things become accepted in trading society, and therefore it'll be slow to respond to developments. Now, one might say, well, you can always move to the second question as to whether they're reasonable or not, with something that's novel or hasn't perhaps become an accepted part of the way in which commercial business is transacted. So there is a safety net. One's not saying that automatically you'll fall foul of the doctrine simply because it's not a normal or customary step to take, but you will be put to the expense potentially or the inconvenience of having to establish whether it's reasonable or not. But perhaps that's the answer, that for a short period of time that may have to take place, but in due course innovative steps will become normal and part of a trading society. And it does have that benefit of flexibility, albeit it might be slow to catch up with developments.
Thank you.
I mean, it's only a headline. You've called this the trading society test.
Yes.
I think it might be more accurate to say it's the incremental test.
Yes. And from a point of view of development of the law in principle, it has an attraction to it, in that if we start from the proposition that restraint of trade is an interference with freedom to contract and therefore should only apply in limited cases, it's better that it only occurs in incremental ways, that if society and commerce has regulated affairs in a certain way for a period of time, then the law should allow that to persist. But if issues are thrown up by different forms of agreement, then the law still has an opportunity to examine those.
Yes?
That's 172B. He makes the point that the line of thought that restrictions may in some contexts be imposed and upheld where they've come part of the accepted pattern or structure of a trade as encouraging or strengthening trade rather than limiting trade is, I think, behind the court's acceptance of exclusivity contracts and contracts of sole agency. So again, looking at what might prima facie be thought to be a restraint might actually be something that benefits tradesmen and strengthens their position. In his analysis of the position generally at the bottom of the page 172, having mentioned some of the cases, he says these illustrations are sufficient to show that the courts are not lacking in tools which enable them to select from the whole range of those contracts which in one way or another limit freedom in trading, segments of current and recognisably normal contracts which are not currently liable to be subjected to the necessity of justification by reasonableness. Such contracts may be listed provisionally in categories, but the classification must remain fluid and the categories can never be closed, which is your Lordship's incremental point. He talks then about, just briefly, about the agreements in issue in that particular case, and he says at C, in my opinion, on balance, they enter into the category of agreements in restraint of trade which require justification. They directly bear upon and in some measure restrain the exercise of the respondent's trade. We say that's a key part of the reasoning of Lord Wilberforce. It's about his trade. So the question is whether they are to be treated as falling within some category excluded from the doctrine of restraint of trade. The broad test, or rather approach, which I have suggested, is capable of answering this. This is not a mere transaction in property, nor a mere transaction between owners of property. It's essentially a trade agreement between traders. And respectfully, we submit that the opposite is true. In the instant case, we are not here dealing with a trading agreement between traders. We are dealing with a transaction between owners of property. And for that reason, this situation should fall on the other side of Lord Wilberforce's line. There is key distinction, we say, between the ESO situation and all those other solus agreement cases and the situation which prevails in this case. In this case, the covenant in question burdens land, but it also benefits neighbouring land. In the solus agreement cases, there is no such benefit-burden relationship because the oil companies do not own any adjacent or proximate land. The land leased to Dunn Stores benefits quite clearly from the restriction on the adjoining land, which is now owned by Peninsula Securities. It doesn't actually matter whether one had created that as a freehold covenant, because that could then be enforced pursuant to Tulk and Moxey by virtue of the existence of the land proximate benefiting from the covenant, or indeed whether it's a leasehold covenant, which is then enforceable by successors under the provisions of DC's Act. What both those situations illustrate is that neighbouring landowners create parcels of obligations between themselves, and there is never, we say, a reason for restraint of trade to intervene in those arrangements. And perhaps more significantly, even from my hoped-for statement of principle, is the fact that there's not a single authority where the doctrine has been applied to restrictive covenants effective between two neighbouring landowners. The case that perhaps touches most clearly on this is the Australian case of Quadramane and Sevastopol, which can be found in Volume 2 of the Authorities at page MS 607, or tab 30. It will be noted, my lords, my lady, that my submission takes out the rather difficult anomaly thrown up by the majority view in Esso Petroleum, because we say that Mr. X and Mr. A, as neighbouring landowners, can regulate their affairs as they please without the doctrine ever being invoked, either as against one or t'other. And that is really where one gets to on an analysis of this Quadramane case. If we start just with the head note, because it summarises the facts neatly, the owner of adjoining pieces of land transferred Lot 2, subject to a covenant that the land would not be the subject of an application for a liquor licence. The covenant was expressed to be made by the transferee for himself and the owners and occupiers for the time being of Lot 2, in favour of the transferor and the owners and occupiers for the time being of Lot 1. At the date of the transfer, Lot 1 was used as a hotel. The owner for the time being of Lot 1 subsequently sought to enforce the covenant against the occupier for the time being of Lot 2. And it'll be seen the majority of the High Court of Australia held that the covenant was not in restraint of trade according to the principles of the general law or under the statutory provision. The analysis which the majority agree with is found in the judgment of Justice Gibbs at MS 616. And he begins by saying that these proceedings were commenced in the Equity Division of the Supreme Court of New South Wales, that Quadramane is the owner of land in Aurora, described in Lot 1. The defendant is Metropolitan, which is the owner of an adjoining Lot 2, and Sevastopol holds a lease for Lot 2. and had been substituted as a defendant. Before the 22nd of August 1969, both lots 1 and 2 were owned by Barora Heights Hotel Proprietary Limited, but on that date the company transferred lot 2 to another company called Holloway Sackville. So one can see that there had been changes of ownership of both lots during the time prior to the litigation. And then they set out the covenant, which is effectively not to make any application for a liquor licence in respect of lot 2. Picking up then at the 617, at the date of the covenant, lot 1 was used for the purposes of a hotel. It is still so used. Lot 2 was at that date intended to be used as part of a shopping centre and now has a shop erected upon it. And then he recites that lot 2 was then transferred and lot 1 was subsequently transferred, etc. And in 1975, Sevastopol, by this stage in occupation of lot 2, made the application for a liquor licence. And then one can see, just over halfway down the page, by way of defence to this summons, it's asserted that the covenant relied on is unreasonably in restraint of Sevastopol's trade and is therefore void. Whenever the owner of lot 1 tried to prevent the application being made. We don't need to consider the Trade Practices Act, and over the page on 618 is the analysis of the restraint of trade doctrine. The second paragraph begins, both defences raised by Sevastopol must, in my opinion, fail. In the first place, I consider that the rules relating to restraints of trade have no application to the present case. Of course, it's now settled that those rules are not limited to particular kinds of restraint. The categories of restraint of trade are not closed, petra fina, and indeed the rules are not confined to contractual arrangements, but apply to all restraints of trade outside imposed. It's also settled that the rules apply to a restraint which extends only to the use of a particular piece of land. And he references SO Petroleum. All members of the House of Lords who took part in that decision agreed that the rules do not apply to a covenant given by a purchaser or lessee restricting the use to which the land purchased or leased may be put. In such a case, the covenantee is not required to establish that the covenant is reasonable. The covenant is not subject to the doctrine. Different reasons were given by the Lordships in support of this conclusion. The view of the majority, I note that Justice Gibbs only thinks 3 of their Lordships, where that majority was that the doctrine only applies where a person gives up some freedom which he already possesses. Lord Wilberforce adopted a more flexible test, which may in time come to be preferred. He said that an exemption of these transactions from the doctrine of restraint of trade should be explained by saying that they have become part of the accepted machinery of a type of transaction which is generally found acceptable and necessary, etc. We just can skip a few lines to, it is unnecessary for present purposes to consider whether either of these statements of principle correctly defines the limits of the doctrine. The conclusion that the rules relating to restraint of trade do not apply to restrictive covenants given by a person purchasing or leasing land should be accepted as correct, at least as a general rule. The doctrine of restraint of trade is based on public policy, where a purchaser with a view to obtaining a particular piece of land which he could not otherwise acquire or could acquire only on paying a greater price, freely gives to the vendor a covenant for the benefit of the other land of the vendor that he will not use the land purchased for the purpose of trade generally or for the purpose of particular trade. There is, speaking generally, no possible reason of public policy that would require such a covenant to be invalidated. The same is true where a purchaser or lessee chooses to buy or lease land already subject to restrictive covenant. And he concludes that paragraph with the public policy has no possible operation. The rules founded on it have no application. So this is a lessee covenant again, of course, but one can see the very strong decision of the majority of the High Court of Australia that it's really no business of the law, certainly not the law of restraint of trade, to involve itself with a consideration of the reasonableness or otherwise of restrictive covenants freely entered into by neighbouring landowners.
Yes.
The second issue for the court, if it's determined that Mr. Shorthall can or could at the relevant time have invoked the doctrine of restraint of trade, is whether his successor in title could do so. The Court of Appeal in Northern Ireland accepted that a literal reading of the Esso Petroleum decision led one to the view that the successor in title could not invoke the doctrine, even if the original party could have done so, but held that the public interest required that the provision in question still be subject to the doctrine. And we say in doing so, that court fell into serious error, both in principle and precedent, in finding that the literal interpretation was somehow disapplied. Because one remembers that the foundation of the principle, whichever it is public policy. There is not some principle that then public policy is subsequently applied to. It is the public policy itself which ought to lead one to the conclusion to the first question, which is whether or not the doctrine actually applies. In this case, we know there was a time lapse of a couple of years between the lease being entered into with Dunn Stores and Mr. Shorthall deciding to transfer his interest in the property to a limited company under his control. Now, no doubt he did that for good, sensible commercial reasons. It may well be that there was a tax benefit. It may well be that it was a sensible way to order his business's affairs, was to incorporate a company to take over the role of lessor of these premises. However, this is very far from the facts of cases like Alec Loeb and Total Oil, which can be found at MS 21, or indeed the Amoco decision in Australia. In both those cases, no doubt conscious of the effect of the decision in Esso Petroleum, the parties, or rather their lawyers, one imagines, contrived conveyancing devices to try and avoid the consequences of the Esso decision. So rather than having a new covenant entered into, there was a lease followed by an underlease. And in those cases, it was being said, well, because there was an underlease back to the retailer, he couldn't then seek to invoke the restraint of trade because he wasn't giving up any pre-existing freedom. And the courts, perhaps not surprisingly, saw this as simply being a device to avoid the applicability of the doctrine. And significantly, there had been, if there was any scintilla between the conveyances, it was only that, and that in each case the retailer hadn't actually given up possession or ceased trading. And so by entering into transactions of this nature, there was just a rather barefaced attempt to disapply the doctrine.
In each case it was a sham.
Well, the courts didn't need to go so far as to say it was a sham, because I think they were keen to say there were still taxation and ownership issues around the transactions which were legitimate, but that it wasn't simply going to be allowed to disapply the doctrine if, in all the other circumstances, it would apply to the case. In the instant case we're dealing with here, there's no such issue. There is, as I said, there's a time lapse of 2 years, and simply because Mr. Shorthall is himself the 99% owner of the limited company, doesn't lead one to any alternative conclusion that this is a separate legal personality which has entered into a transaction to acquire property, which property is itself subject to a restrictive covenant. And certainly there's no suggestion that, or there could be no suggestion that Peninsula Securities wasn't fully aware of the existence of the covenant, since the lease is registered as a burden on the registered title to the folio. So having taken with full notice of the lease, the limited company takes with full notice of the covenants contained in the lease, including the provision that we're considering in this appeal. And so we say that even if Mr. Shorthall fell into a different category because he gave up something, he gave up something of his freedom, a freedom perhaps to develop his land in a certain way, which no doubt my learned friends will contend is captured by the pre-existing freedom. That simply cannot apply as a matter of principle to the limited company. In exactly the same as the Quadramane case, where Sevastopol acquired the title, it did so with full knowledge of the restriction, and in full knowledge that such covenants, whether they're freehold or leasehold, can be enforced against successors in title by the party who benefits from the provision. And one thing that's consistent in the authorities, and it's hard sometimes to find a consistent thread, but one thing that is consistent is that there's no public policy in those circumstances which would entitle the limited company to argue that the covenant is in restraint of trade.
It is rather odd that if public policy is such as to lead the law to say we really must look in to the reasonableness of this, the doctrine applies, then all of a sudden, because of this transfer, that public policy changes and there's no need for the law to look into it. It's odd, but the oddity may arise from the pre-existing freedom test itself, Mr. Humphreys.
That's right. That's right. That may be where our proposition starts, but it also starts from the much older line of authority that says that if you acquire a property to which there's a restrictive covenant in operation, you take the burden of that covenant, and you cannot seek to invoke the doctrine of restraint of trade. And what that may illustrate is that essentially the doctrine is about personal rights rather than property rights. What we're concerned with is petrol station retailer or the young musician, not about who may acquire property in the future and whether and to what extent they can complain that a restriction ought to be unenforceable. And that's again why we say that this doctrine should be very rarely applied in property cases, properly understood, because it's all about the personal restraint on tradesmen and not about how property owners choose to organise their affairs.
You say rarely. Could you just give me an example of what would be a rare case?
One can see that if, as part of a loan package, a supplier, in the 1960s they all seem to be petrol, but in the modern era it could be of any particular goods, where a supplier would only do business with a particular retailer if it entered into a covenant with it to accept only its goods and only its goods at whatever fixed price the supplier determined should apply. And that's part of an arrangement where a retailer needing finance borrows money from a supplier and enters into this arrangement, presumably secured by way of a mortgage or charge. That would be a land transaction, but the character of it would be largely personal. And one can see in that situation, if it proved that the covenant entered into by that particular retailer was proving to be, as the Solus agreements did in the 1960s, restrictive of trade and rendering the chances of making money much less likely, then the courts may think it was appropriate to intervene in those situations.
So the court looks to the substance and not the form in this
Yes.
area of the law.
And I think that's right, because if you had the pure dichotomy between personal contracts relating to trade and property transactions, once again, the well-resourced party with the benefit of good legal advice will try and turn the personal into the property, and will try and engage some element of proprietary rights around a restraint to try and take it one side of the dichotomy rather than the other. And I think that's why we would accept there's still a role for restraint of trade to play, albeit a limited one, and perhaps only to be developed in the obvious cases where there is potential for abuse or inequality of bargaining power between the parties. And again, that can be part of what a trading society would expect, that property transactions are to be respected and upheld, except where on the very boundaries of their operation, they're doing so in an unfair or oppressive way.
Yes?
I mentioned earlier this question of whether a covenant which is entered into in restraint of trade and is found to be unreasonable renders that provision either void or unenforceable. It's part of the learning of going through all these cases that sometimes those words are used interchangeably. Sometimes there's a clear preference for one rather than the other, but there's certainly not a consistent approach. Perhaps in the older cases, the Nordenfeldts and so on, prefer the use of the word void, but by the time of Esso and Harper's, the language is much more of unenforceability. And we say the latter approach is clearly correct. The reason being that a contractual term which is void has no legal effect whatsoever, whereas an unenforceable term remains valid but simply cannot be sued upon. As a matter of principle, we say that covenants in restraint of trade which are unreasonable must be unenforceable rather than void. The parties can, as Lord Reid observed in Esso, can continue to operate the contract quite freely, but if it's unenforceable and the party who benefits from the covenant goes to seek to enforce it, then he can be met by the doctrine as a defence. The respondent in its written case says...
When you say where the doctrine applies, it's unenforceable, do you mean where the doctrine applies and it's unreasonable?
Yes, absolutely, Lord. Yes, it has to, of course.
It's unenforceable.
Both those hurdles have to be
Okay.
passed before you get to the point where, where it's unenforceable. In its written case, the respondent says that the validity of the covenant is considered at the time it was entered into. This is part of their argument about how they avoid the consequence of the acquisition by the limited company. And they're right to a limited extent that you do consider the covenant at the time it was entered into, but only as to the question of reasonableness, not scope. And this is part of the Lord Wilberforce direction to consider the two questions separately. Is the covenant, is the doctrine subject to the covenant? And secondly, is it reasonable? The position we say is that even if the court were to conclude, which is obviously against our primary argument, that the doctrine could apply vis-a-vis Mr. Shorthall, it doesn't necessarily render the covenant unenforceable against a subsequent purchaser of the title. We say it's quite logical for a covenant which may be found to be unenforceable against one party to be enforceable against a different one. And there is authority to this effect. So, of course, this court won't determine whether the contract is unenforceable in any event, since the question of reasonableness remains outstanding. But if it takes the view that the doctrine applies, we say it shouldn't then take the view that it must ergo definitively apply to a subsequent owner of the title.
I understand you to submit that the issue of reasonableness is considered as at the time the covenant was entered into.
Yes, that seems to be a consistent thread in the authorities, that's when you look at the question. So you'd look at the issues of the circumstance in which the parties found themselves and the bargain they struck and so on, rather than looking at how matters may have evolved over the years.
It was unreasonable at that time. It can't subsequently become reasonable.
But the point is that the subsequent purchaser can't invoke the doctrine at all. So they don't get past issue 1, they don't get to issue 2. So the Peninsula Securities Ltd, having acquired the title subject to the covenant, we say, cannot then say that the doctrine doesn't apply. Sorry, it does apply. So therefore it doesn't get to the question of reasonableness. Only the anterior question is asked. And therefore it remains enforceable. And in a
I'm sorry, it's my fault.
Sorry, Lord.
This point about enforceability rather than voidity, this point about looking at the matter at the time of the creation of the covenant, how is this said to impact upon the issues before us today?
Well, I think my learned friends will contend that the covenant falls within the scope and therefore will always be within the scope of the doctrine, that must be right, because once it's potentially unenforceable, it has to be unenforceable against a subsequent successor in title. And we say, in the first instance, you can't automatically say that because the question of reasonableness remains to be determined, but B, as a matter of principle, that's not right. Even if it was unenforceable, even if we assume for a moment that it was unenforceable against Mr. Shorthall, that doesn't mean that it's unenforceable against the subsequent owner of the title.
Doesn't the subsequent owner of the title, in our type of situation, become an assignee and therefore entitled to all the rights which were vested in the assignor?
They become entitled to the property rights, but not, we would say, the personal right to seek to invoke the doctrine, because they don't fit into the principal test, because they've acquired with knowledge of the covenant that the covenant's registered as a burden on the lands, and therefore it's enforceable against them, even if the person, the assignor, would have been in a position to contend that it's not enforceable against him.
Thank you.
This shifting of enforceability arises in a different but connected situation in Passmore and Moreland. Both the first instance and Court of Appeal judgments are in the papers, and the Court of Appeal completely uphold the judge of first instance, but the judge of first instance statement of principle is quite straightforward, so if the court's content, I'll refer to it. And it's at MS 355 at tab 18 of the Authorities bundle. It's volume 2 of the Authorities. And one can see that this is a case argued under European competition law. In the head note, it says that the plaintiff entered into a lease of a public house with the second defendant, IEL, for a term of 20 years. One of the covenants contained in the lease required the plaintiff purchase beer from IEL and no other supplier. With the result, he was obliged to purchase beer at a higher price than was available on the competitive market. On July 1992, the first defendant, M, a small regional brewer, acquired the legal and beneficial interest in the public house and thereby became the plaintiff's landlord. Thereafter, the plaintiff's solicitor wrote to M stating that the beer tie contained in the lease was void ab initio as a result of the provisions of Article 85 of the EC Treaty, and that it remains so, irrespective of the identity of the owner of the freehold reversion, so that the tie was unenforceable by M. It then recites what Article 85 provides about agreements between undertakings, and notably Article 85(2) provided that agreements or decisions so prohibited shall be automatically void. Then proceedings were commenced, but the plaintiff accepted that a lease in precisely the terms of the one which was assigned to him would be valid and enforceable if entered into de novo by him and M plc, but contended it was not possible for IEL to assign a lease containing the tie once it had been established the tie infringed Article 85, and this was a striking out application. And the held says that, having regard to the fact that Article 85(1) did not prohibit clauses of particular form or language, but only prohibited agreements and concerted practices which had a particular offensive economic object or effect, it was necessary to look and weigh up all the relevant economic facts before it was possible to say a breach had occurred. It followed that as circumstances changed, an agreement could move into and outside the scope of Article 85(1) and also into and out of nullity, since Article 85(2) only imposed nullity on agreements and concerted practices which offended Article 85(1). In the instance case, the contractual obligations passed to M by IEL on the assignment were inoffensive, as M's tied estate did not significantly contribute to the foreclosure of the market, and as such they were enforceable. And in the judgment of Mr. Justice Laddie at MS 360, actually 361, I think I can skip to 361 at paragraph at C. It says, when contractual provisions are not incompatible with Article 85(1), for example, because they are passed to different parties having a negligible presence in the market in issue, then the automatic nullity of Article 85(2) does not apply. As Mr. Green put it, the statutory prohibition in Article 85(1) operates periodically, i.e. it can be turned on and off depending on the surrounding facts. And at the bottom of the page then, the last 3 lines of 361, the lease between Entrepreneur and Mr. Passmore created a bundle of contractual obligations between them. As and when those obligations came to effects prohibited by Article 85(1), they became a nullity in the sense they were absolutely unenforceable between the parties. If and when the effects of the obligations no longer offend, they are not a nullity and they are no longer unenforceable. The effect of the assignment by Entrepreneur to Moreland was to pass to the latter the bundle of obligations, and in the assignee's hands they are admittedly inoffensive, and in consequence in those hands they are enforceable. Now, it's a different field. Competition law requires different inquiries, all that accepted. And what the judgment does illustrate is that the concept of enforceability is not determined once and for all at a particular moment in time by reference to a particular party. And we say that the contractual obligations that pass here can shift the enforceability in a slightly different way, but in conceptually the same approach, in that just because in the event Mr. Shorthall could have invoked the doctrine does not prevent the argument that in fact the covenant remains enforceable or becomes enforceable upon the assignment of his interest to the limited company.
I think it said against you that the reason why enforceability is not determined once and for all at a particular time, in this case, in Passmore and Moreland, is because of a particular characteristic of EU competition law, that it can be applied intermittently.
Yes, and I recognise the difference in context and the difference in the inquiry that has to be made. But as a matter of standing back, as a matter of principle, I think one can still say the point holds good that the issue of enforceability of a contractual term is not determined once and for all, that there can be situations in which enforceability will shift either in one direction or the other, depending on the nature of the party assuming the benefit or burden of that term. And if one remembers that restraint of trade is all about policy, public policy, we go back to that point that says, well, even if Mr. Shorthall had some restraint imposed on him that the law regarded as being sufficient to intervene and render a term enforceable, that does not mean that the person to whom he assigns his interest has exactly that same right, because public policy can shift just as enforceability of contractual terms can shift.
At this point, you rather embrace Lord Reed's approach.
Yes, at that point, we see that there's much to be said for if you pick up for the first time an interest in property and it's subject to a covenant, well, public policy shouldn't excuse you from honouring that contract. But of course, we also say it fits into Lord Wilberforce's theory as well, in that trading society would recognise that in those situations, there's no reason why the company that acquires the title should be able to invoke the doctrine, having acquired it in full knowledge of the existence of the covenant.
It might be said to be a little of those, my lord, I think, put to you a moment ago. If, focusing on public policy, the covenant which was imposed upon Mr. Shorthall truly is offensive, and he transfers his business to a company for absolutely understandable and legitimate reasons, for tax purposes or whatever, suddenly suddenly one is with that bound, duns, that is to say, are with that bound free.
Yes, and the reality is that it illustrates the personal nature of the availability of restraint of trade. It is about restraint on the tradesman, on the person himself. It's not about the restraint that may pass with particular property from time to time as transactions occur. It's about the person. And so the law generally recognises the Tulkin Moxay, the DC's Act provisions recognise that leasehold obligations are enforceable against successors in title. And that remains the core principle, if you like, and that those successors in title have to accept as a matter of legal certainty and conveyancing process that those are the covenants they're taking on. It shouldn't be open to them to potentially acquire property for reduced consideration because there's a restrictive covenant on the title. Maybe well negotiate a certain deal with the vendor, but then be able to turn around and seek to invoke the doctrine and have the best of both worlds.
You refer to DC's Act. We were mildly intrigued as to why it was so called, but more relevantly, we wondered what the relevance of those two sections was.
It's simply the Irish law of landlord and tenant is similar but slightly different from English law. It's founded, as DC's Act says, on contract, not on estates and land.
Oh, I see.
It's a slight difference. But in practical terms, what those two sections in DC's Act simply provide is that the successor entitled to a landlord, and indeed the successor entitled to a tenant, as one might expect, is entitled to invoke the provisions and be subject to the same restraints as the person from whom they acquired the title.
So where does it take us?
It simply takes us to that point that this is the recognised, if a conveyancing lawyer was looking at this case, they would say simply, well, whenever the transaction occurred, the successor entitled takes, subject to that covenant, whether it was a Tulkin Moxay, as was argued at one stage, or a leasehold covenant. It doesn't take us any further than really that basic first principle.
Okay. Yes, sir. Mr. Humphreys. Now, where do we go next?
Where do we go next? The respondents in their written case state that the court might wish to use this as an opportunity to write a new test, to say that this is all very difficult. Pre-existing freedoms or sterilisation or trading societies, all too nebulous to provide some legal framework and certainty for men of business and for property lawyers and for all of us going forward. What they've offered as their new test is a twofold, and which benefits from simplicity, one has to say. That first of all, you ask the question, is the restraint a restraint of trade? And secondly, if so, can the covenantee show it to be reasonable? So they would invite the...
So they shove reasonableness into the initial applicability of the doctrine.
The first threshold question they put forward is simply, is it a restraint of trade? And then secondly, is it reasonable? Now, inevitably, the affirmative answers to question one will be a great deal more than they are on the current regime, and so there'll be a lot more work to be done on the second question of reasonableness if one was to adopt their proposed approach. In fact, one can imagine it would be the cause of many sleepless nights for commercial property lawyers if they were to believe that every restrictive covenant was potentially subject to litigation on the question of whether or not it was reasonable. Not only would that offend legal certainty, it would also create substantial inconvenience and cost to the party who benefits from the covenant, because as a matter of principle, it would be they that bear the burden of showing it was reasonable on every given occasion that the issue was raised. So we say that would be a significantly adverse development for the law, and one that could only serve to deprive commercial transactions of legal certainty and provide a facility to encourage litigation, which of course some lawyers might promote, but one would think that in the scheme of things, the area of restrictive covenants and restraint of trade should be a limited one rather than opening up every potential covenant to scrutiny. So what if the court doesn't like the pre-existing freedom test, thinks that the respondent's offering is very interesting but far too wide in scope to be realistic? Where does it go? And we say if it has to go somewhere, it almost certainly has to go to the Lord Wilberforce Trading Society test. And it's useful to consider the decision of Justice Heary in Australian Capital Territory and Mundi, which can be found in the third volume of Authorities at MS 1018. That's tab 47.
Yes.
And this is a decision of the Federal Court of Australia. It begins at MS 1025. It concerns the operation of a rubbish dump, and in particular the operation of various licenses that were being offered in order to enter and use the tip and to salvage material from it. The mundane nature of the subject matter didn't prevent a very lengthy and detailed analysis of the law from Justice Heary, which begins at 1030. And he talks at paragraph 27 of his judgment about the anterior question of whether the doctrine applies at all, and the important practical consequences of that. If the doctrine does not apply, no question of reasonableness arises, and the party seeking to justify the restraint does not have the burden of going into evidence. And that's an important principle for the court to bear in mind if it is looking at an alternative test that if the anterior question, the bar is set too low for the anterior question, then this will impose significant burdens on those seeking to uphold restraints. The learned Justice goes through many of the authorities, including quadrimain, which we looked at earlier. But if we pick up at MS 1039 at paragraph 62, Justice Heery says, importantly for the present case, however, it can be said that, one, however elusive definition may be, the common law does have criteria which exclude particular categories of transaction from the doctrine. The proposition that the doctrine is of universal application, but as a matter of fact is not raised in some cases because the restraint is obviously reasonable, appears no longer tenable. So the universal application is effectively what my learned friends are contending for. Roman 2, the fact that the restraint affects the use of a particular piece of land does not of itself exclude the doctrine. And 3, the acquisition of a right in relation to land, which right is at the time of acquisition, subject to the restraint, may be outside the doctrine. So that's issues that he pulls from the authorities. But then when he goes on to talk about what the test should be at 1044, Justice Heery says at paragraph 85, the pre-existing freedom test, like any rule expressed in abstract and generalised terms, has to be applied to an infinite range of possible situations. Anomalies are inherently likely to occur, as is demonstrated by Hayden in the article I mentioned, the restraint of trade doctrine. To take but one of the examples given by the learned author, if V owns 2 shops and sells one to P with mutual covenants that neither shop will be used as a butcher's shop, the doctrine will apply to V's covenants but not to P's, yet the impact on competition is the same.
You've given us an essay by Hayden on restraint of trade doctrine in the Law Quarterly, but that's 1969. This is a 1999.
Yes, I wonder, is it the same?
Is it the same?
Essay brought forward? I'll check that.
We'll check that.
I noticed the change in dates,
Yeah,
but he certainly he makes exactly the same point about the butcher's shops in the Law Quarterly Review, so it may be the same, but we'll check that.
Thank you.
Moving forward to page 1048, paragraph 100. He says, as already mentioned, Lord Wilberforce's trading society test seems to have attracted on balance the approval of the High Court. If one might respectfully say so, it accords more satisfactorily with common law methodology and with the need for the law to adapt to methods of doing business which are constantly changing. While acknowledging the trading society test has the great advantage of flexibility, Hayden does point out some of its drawbacks. Public opinion may be incapable of seeing the evils of the restriction, and commercial people may all be interested in keeping the system going. And will courts be able to apply the reverse process so as to bring within the doctrine a practice once seen as innocuous, but now recognised as pernicious? However, in Australia, there's a substantial statutory competition law regime to be found. Parliament regularly amends this legislation in light of the changing needs of business and consumers and the fundamental importance of competition for the health of the economy. The legislative scheme is enforced by a powerful statutory body, the Australian Competition and Consumer Commission. The existence of such a legislative regime must mitigate the concern that the trading society test may be ineffective to meet changing business practices or community views of them. And we would say that the same position pertains in the United Kingdom, that there is a strong and sophisticated body of competition law now, which has a regulator able to enforce, as well as private law rights in relation to anti-competitive practices. And so,
is it the case here that it's accepted by both sides that the Competition Act doesn't apply?
yes,
It doesn't just engage with the present situation.
it was pleaded, and expert evidence was obtained on the issue. But shortly before the matter came on for hearing, the respondent to this appeal abandoned their case based on the Competition Act. So it was certainly something the parties put a great deal of time and effort into considering, but ultimately the mutually accepted position was arrived at that it wasn't engaged on the facts of this particular case. But of course, there are other situations where agreements between undertakings may well fall foul of the competition legislation. And that's a modern context for the restraint of trade doctrine. Whilst back in the 1960s in the SOLAS agreements, there would have been Restrictive Practices Act through the 1950s and later in the 1970s. The modern law of competition really finds itself from 1998 onwards, but might allow a court now considering changing the test, might take some succour from the fact that at least part of the area, previously the domain of restraint of trade, might find protection in a given situation through the invocation of competition law. But as we recognise, the two do still stand separately and can be argued separately, and indeed in this case, as we now know, only one could be argued. The learned justice continued that in any case the common law doctrine 103, this is necessarily leaves a large gap in the regulation of anti-competitive conduct. Parties to an agreement or arrangement in restraint of trade will, as long as they happen to find it mutually beneficial, be unaffected by the doctrine in any practical way. When one party does seek to invoke the doctrine, it will not usually be for any lofty motives of public interest. It's not escaped the notice of the courts that sometimes parties of relatively equal bargaining strength freely enter into a contract, but later one finds a more attractive proposition elsewhere and seeks to be released. And one of the additional benefits of competition law is, of course, it can be invoked by third parties. So the restraint of trade doctrine can only be used by the existing parties to an arrangement or contract or a lease. But a third party could intervene, say someone else who wanted to sell textiles or groceries at a particular store in a shopping centre, and could say, but this arrangement between these people is offensive. It's offensive to competition law, and the regulator should intervene. And so there is greater breadth, in one sense, to competition law in terms of its availability to those who aren't the original or parties to the arrangement, or indeed their successors in title. But paragraph 105 then, Justice Heery concludes that the trading society test should be adopted. And so that was in 2000 in Australia, and has become the test, as it were, for the applicability of the doctrine in that jurisdiction. And
you mean become the test as a result of this decision?
Yes.
Or become the test as a result of later decisions confirming it?
Both. In fact, it was part of a line of decisions that had begun to express preference for it. But then when Justice Heery said it should be adopted, then in subsequent cases, including the next one, in the bundle of authorities, Barramon, it's confirmed that the trading society test is to be adopted. Right. So that's the situation this court then finds itself in, is it can, we respectfully say, answer the question in favour of the appellant by applying existing principles, and in particular by applying the pre-existing freedom test on the first principles of restraint of trade. It could equally adopt the trading society test or some variant of it, an incremental based test, but still we say respectfully find that trading society respects and upholds these types of covenants. It could also take the view that in these particular circumstances, on whatever analysis, whatever test applies, the owners of neighbouring properties who who choose to regulate their affairs through the use of restrictive covenants have not had and should not have this doctrine invoked against them, and that therefore, whatever the test might be, property transactions, unless they're very unusual, simply don't fall into the scope. Or, fourthly, the court might say, well, we actually do believe that Mr. Shorthall could have invoked the doctrine in respect of this particular covenant, but the successor in title cannot. And that on any one of those four analyses, we say the appeal should be allowed.
Back for a moment to my Lord's question about the status of the decisions in Australia.
Yes.
Has the trading society test been accepted by the High Court of Australia?
There is a series of decisions of first instance following Monday where it has been applied.
Two to which you referred are first instance decisions in the Federal Court of Australia.
They are.
Yeah.
And that seems to have, but that there has been no High Court authority that I'm aware of, but it just seems to have become the adopted position. Following, I think Quadramain certainly expressed a preference for it, and without actually, and it of course was a High Court case, it expressed in the mid-1970s, I think, a preference for it. And then it appears to be in the first instance judges.
I think for completeness, you'd better give us a list of the Australian decisions after Australian Capital Territory which adopt Judge Heary's approach.
My Lord, I will do. My Lord, the next thing I wanted just to touch upon was the alternative remedy that's open to the respondent under the property order. As we know, there was a potential alternative remedy under the Competition Act, which was considered and abandoned. But it is significant that the respondent, if there is some mischief imposed or created by this covenant, that the inquiry doesn't end at the point of the analysis of whether the restraint of trade doctrine applies. But I'm conscious that your Lordship and your Ladyship were keen to see the English and Welsh provisions side by side with the Northern Irish property order to observe if there are differences, how they might be material. The property order is in the papers, and I could go to that, but it might be more convenient to see if we can have a look at Section 84 and its evolution from the Law and Property Act and compare that.
I mean, it's relevant as background, but I mean, do we need to know more than there is a jurisdiction in the English statutes, which is comparable but not necessarily identical? I mean, the background is that there was, the 1925 Act had Section 84, which allowed modification in fairly restricted circumstances, and then it was broadened in the 1969 Act
Yes.
to circumstances which are much more general. But I'm not sure they're any different in substance to those that are now in the Northern Irish property ordinance.
I agree with what Lord Carnwath has said. It was I who raised,
Yes.
well, what's the English and Welsh dimension of this? But I don't think we want to study the English and Welsh dimension in any detail.
No.
Are there any particular aspects of the Northern Irish property order that you would like to bring to our attention?
Yes, the legislation...
Why is it so much better for you that this dispute be decided under the order than under the doctrine of restraint of trade?
There are lots of reasons why the parties should prefer that route. The first of which is that the property order allows for total flexibility in terms of how a covenant is modified. The restraint of trade doctrine, if it applies to render a covenant simply unenforceable. It doesn't rewrite the covenant to make it enforceable. It doesn't try to release or relax the prohibition. It simply says that the party seeking to enforce it can't rely upon it. The modification would allow, for instance, and this was the initial position of the respondent in this case, to increase the size of the units that could be constructed on the adjoining land without infringing the covenant. If it were said that modern shopping preferences, that modern shopping centres and consumers prefer larger stores, that it's not economically viable for small stores to compete in this environment, and that therefore the context has changed to the extent that a 3,000 square foot restriction is no longer viable, then that argument could be made, maybe countered by alternative arguments, but the Lands Tribunal or the High Court, whoever was determining it, could say that the covenant should be modified to 10,000 or 20,000 or 50,000 square feet without the parties completely losing their bargain. They would be able to say that a modification to reflect modern planning trends or modern consumer needs can be imposed, because the ultimate test being that the covenant, following the lapse of a period of time, had become an unreasonable impediment. And that's perhaps the second reason that it's a better remedy, is that it can look at matters as society and economics changes. Restraint of trade doctrine, the authorities are pointing one back to the analysis of the question of reasonableness taking place at the date the covenant's entered into. It doesn't seem to admit to a process of examining how the matter has changed over time and how the interests of the parties and indeed society generally might be different than they were many years ago when the covenant was originally entered into. It can also, of course...
We could have a look at the covenant, at the Act.
Yes, MS 18.
Yes. I mean, the key to it is on page 19, isn't it? 5.5, where you can take into account changes in the character of the land and the public interest.
So Article 5.5 sets out some of the factors the Lands Tribunal will take into account, and specifically how the public interest might change with strategic development plans of land, which might be very relevant in the case of a shopping centre, particularly from the 1980s to 2020. The strategic use of land and the best use of land may well have changed quite substantially in any given area, and that's something the tribunal can follow in terms of modifying the impediment. The court then has like powers. This is my Lord Wilson's point about is everything be dealt with by the court. I think we agree that Article 6 powers that rest in the court rather than just in the Lands Tribunal.
Of course, there's the important 5.2, which says that you normally can't do it for 21 years.
If one looks at the Hansard for the 1978, there was perhaps not surprising in the context of Northern Ireland legislation, a very late night debate involving some of Northern Ireland's politicians, including the Reverend Ian Paisley, who was worried that this would be licence for all sorts of immoral activities to suddenly become the norm in Northern Ireland, because much land was subject, and maybe still is subject, to restrictive covenants around liquor licensing. And so he saw this as a dangerous way in which immoral activity could become commonplace in the north of Ireland. He was reassured, I think, somewhat by the fact that the tribunal would still have control of it and that there was this 21-year limitation. But of course it is subject to the permission of the Lands Tribunal, so there are situations in which you may be able to persuade a tribunal to modify earlier than the 21-year period. But in any event, as we know, by the time Mr. Shorthall started his proceedings, he was well beyond the 21-year primary period for modification.
Mr. Humphreys, the covenant is against allowing shops selling textiles, provisions, or groceries. And just reading that yesterday, I wondered whether it was immediately obvious to everybody what provisions meant in this context. And if it wasn't, whether that is something that a modification could clarify. But perhaps the parties are entirely clear about what provisions means.
I certainly, reading it myself, thought it was rather tautologous to have provisions on groceries. I wasn't quite sure what the distinction was. It may be that in retail terminology there is a distinction.
Maybe.
But it's certainly not one that jumps off the page.
No.
But certainly the business of dumb stores would be very much recognised as clothing, textiles and groceries. Certainly they've expanded considerably since the 1980s, but those would have been their two fundamentals at the time that this particular lease was entered into. So quite what provisions adds, I'm not sure. But if I can find out, I'll let the court know. So we say that there is the alternative remedy point should lead the court to be confirming the view that the law should have anyway, that there is no great pressing need for the restraint of trade doctrine to find its way into the land dealings between landlords and tenants and commercial property. That Parliament has legislated for that, has created a very flexible system where the interests of both parties can be taken into account, whether at the initial time and subsequently in accordance with the development and use of the land. Now, I did say to my lords that we would endeavour to obtain those two cases.
Can we just run through what we are hoping your team will be able to achieve over the short adjournment?
That would be very helpful.
You're going to explain the difference between folio land and adjoining land. You're going to at least refer us to the sections in the 1969 Act of England and Wales that amends the section which you gave us from the 1925 Act.
Yes, my lord.
You're going to give us 5 copies of the Hind case and the Aberdeen case. You're going to tell us whether Mr. Justice Hayden, as he became, wrote a different article in 1999 from the article he wrote in 1969. And you're going to give us a list of all the Australian cases which, as you say, confirmed the conclusion reached by Judge Heary in the Australian Capital Territories case. Is that okay?
Yes, I'm very content with that, my lord.
Right. Well, then we'll resume at 2:00.
Thank you very much.